Good morning, welcome. If you are just logging in with us, we'll be starting here in a couple minutes. So I'm just going to give all our 500 attendees a second to log in. Okay, we're up past the 300 mark. I did want to, I've gotten a couple questions in the questions box. If you're having any issue hearing, we've tested everything on our end. And so you should be hearing us. So I would check your audio settings, possibly your speakers, and make sure those are all turned on or have the computer audio function selected. Give it just another minute.
I think we probably need to keep talking for folks who are still trying to adjust their audio.
Yep. Okay, well,
they're not here.
Okay, good. Well, then we'll go ahead. I keep seeing the attendees list climbing, so I know people are still logging on. But again, if you're just now joining us, welcome. We're so glad that you could join us virtually today. My name is Jacqueline Rathman. I'm the Contract Administration Director for KHRC. The training session you are about to attend is called All is Fair in Fair Housing, and it's going to be presented by KHRC's Senior Compliance Officer, Tim Herrman. Tim has almost 20 years of compliance experience, and 13 of those are working here at KHRC with us. Some things to know during the presentation. I'll be serving as the moderator, and Caitlin Ramirez, KHRC's Senior Administrative Specialist, will be our technical support during the webinar. I know there was a question in the chat box about certificates. Yes, if you are active participants in the session, you should receive an automatic certificate via email in the next day or two. Some other technology tips I want to make everyone aware of to limit distractions during the presentation, because we do have about 500 people that are logged on and attending. We are going to have everyone's mics muted and all the cameras turned off. So if you do have questions during Tim's presentation, please type your question into the question feature box on this GoToWebinar panel. And I'll have a screenshot here on the next slides to kind of show you what that looks like. I know several of you are probably familiar with that at this point. But Tim will try to answer some questions as he sees them come through. However, there will be a spot between each fair housing topic that he goes over to answer questions that he didn't get to. So I'll read those to him at those spots in between each topic. Like I said, this is a full class of about 500 attendees. So we will do our best to get everyone's questions answered, but we do have limited time. So if any questions don't get answered, we're able to keep a log of those, and we can send out a blast email to make sure we get all those questions answered for you. We also are recording this session, this webinar. So there's no handout specifically for the presentation, just the two handouts, the Assistance Animal FAQ handout and the FHEO notice. Those are the only two paper handouts we have for this webinar. But if you miss some of it, or you have to log off early, or you weren't able to attend, we are going to record and make it available on our website here the next week. It takes a little bit to compile that. So that should be available also on our website. Also, speaking of handouts, if you should have received them via the Dropbox link that Caitlin sent out in the webinar reminder emails. But if you didn't get a chance to, we have also uploaded the two handouts on the handouts feature on your GoToWebinar control panel. You can open those and download and follow along as we go. Tim, go ahead and do the next slide. I'm going to see if that control panel, there we go. So this is the control panel feature for GoToWebinar. That's where there should be a handout section where you can find the two handouts, and that questions box. If you click on that arrow next to questions, it will make it larger, and you can post your questions in there, and we'll try to get to them as we're going through. Okay. It looks like we've stalled out a little bit on attendee numbers, so I'm assuming everyone's logged in. Tim, I'm going to turn it over to you. Thanks, everyone.
All right. Good morning, everybody. I know some of us are still working on some sound issues. Hopefully we can get those fixed. I'm gonna just kind of drag my feet a little as folks work that out. If you go into your audio button, try to bring this here, there's an audio button. You may need to try to select. Caitlin, do you know if we have a phone number that they could call in on their cell phone so they can watch but use their cell phone to get in?
Yes, I believe it would have been included in their registration confirmation email.
Okay, so for those of you who are still having audio issues, you may want to try and do a phone call in on your telephone. And then that way you can still hear and then follow along on the presentation. And then if that doesn't work, I'm like really not a techie guy, so I don't know what else to offer and a suggestion for that. All right, well, this is April. As you all know, it is Fair Housing Month. So thank you guys for taking the time to sit in through this. I am going to go through some legal mumbo jumbo for y'all first off to get the little details out of the way. First off, when you're attending a training, make sure you always follow your company policy, regardless of what you hear me say to you today. You should always consult your supervisor before you make any decisions, and before you make any decisions related to this fair housing or what you hear in this fair housing course. Always talk to your supervisor first. Should also always consult your Section 504 coordinator if you have one. They're the person that's supposed to help make sure that you're complying with fair housing. And finally, you should always consult a fair housing attorney when you have questions. Those are the folks that will stand next to you in court. Now, the reason I remind you of this and tell you all this is because I, Tim Herrman, am not an attorney. I will not go to court and testify on your behalf when you tell the judge what Tim Herrman said. And I will not pay your court costs or any other fees that you incur. I will not bail you out of jail. And I will not even visit you on visitation day. So please make sure you consult your company policy, your supervisor, 504 coordinator, or your attorney before you make any changes to policy procedure or when you're working through fair housing. Okay. Today, we're going to talk about the history of fair housing. We're going to go through the protected classes, some prohibited actions. We're going to talk about reasonable accommodations, Section 504 of the Rehabilitation Act of 1973, and assistance animals. Now, there are lots of other things in fair housing that we could talk about, like ADA building requirements. I'm not going to go into that today because that's actually another lengthy discussion that we could have. We're really just trying to give you guys a good coverage of the basics of fair housing, the basics of the prohibited actions, and then some basics in reasonable accommodations. Okay. So let's start with the history. Back in 1964, the Civil Rights Act was passed. It was signed into law by Lyndon B. Johnson. When the Civil Rights Act was passed, it prohibited discrimination on the basis of race, color, national origin, sex, and religion. And the Civil Rights Act basically provided equal access to public places. It banned employment discrimination. It enforced desegregation of schools, and it enforced the right to vote by removing barriers. And those barriers were like the Jim Crow laws. There were also states that had literacy tests in order to allow people to vote. And the Civil Rights Act of 1964 was enacted to help remove those barriers to voting rights. In 1968, 4 years after the Civil Rights Act was passed, and 7 days after the assassination of Martin Luther King Jr., Congress passed Title VIII of the Civil Rights Act. That is what we know today as the Fair Housing Act of 1968. The Fair Housing Act in 1968 prohibited discrimination by direct housing providers, such as landlords, real estate companies, banks, and other lending institutions. Now, it covered most housing providers other than owner-occupied buildings with no more than 4 units. So if you owned your home and you live in your home and you were renting out 2 of your spare bedrooms, you would not have been covered under the Fair Housing Act. If you are a single-family housing that you're selling or renting without using a broker, so if I have a home that I'm holding as an investment and I decide I'm going to rent it out, but I'm not going through a management company, I'm not using a broker to sell it or rent it, I'm just doing it by myself, I would not be covered under the Fair Housing Act. And then the last group that's exempt would be housing that's operated by a religious organization or a private club that limits occupancy to members. And that would be something like a convent or a monastery that has houses nuns or priests is one example. Fraternities and sororities would be another example. You have to be a member of that club in order to live there. Okay? But the rest of housing is covered, and that probably includes most of the folks that are here online. So that's excellent. I'm glad you guys are here. So the Fair Housing Act, when passed in 1968, protected race, color, national origin, and religion. So even though Civil Rights Act included sex, it was not originally included in Title VIII of the Fair Housing Act when it was passed in 1968. However, in 1974, the Fair Housing Act was amended to include sex, and then it stayed that way until 1988 when it was updated again to include familial status and disability. I'm going to walk through these each and kind of give you an explanation of what each of these mean just to make sure that we're all clear on them, okay? So the first one is race, and that determines if that's whether you're white, you're black or African American, Asian, Native American, Alaska Native, a Native Hawaiian or Pacific Islander, or if you're a mix of any or all of those. So as we know, we're a very diverse country, and we cannot discriminate based on somebody just because of the race that they belong in. The next class is very similar, which is color. But color actually refers just to the pigmentation of your skin, like how light or how dark your skin is. Not every Caucasian person is the same color of white. Not every African American is the same color of black. There is a wide range in which people fall, and the Fair Housing Act protects you based on that pigmentation of your skin. okay? The next class is national origin, and national origin encompasses your birthplace, your ethnicity, your ancestry, your culture, or your language. So if somebody comes in and they don't speak English and they speak Russian, you would not be able to discriminate against them because they don't speak English. Or in Kansas, we actually have a separate protected class of ancestry that's actually included in national origin, but that's kind of like where your dad, your grandpa, your grandma, your great-grandparents were born. But you cannot discriminate because somebody's grandparents were not born in the United States. The next protected class of religion. Religion covers those with the belief in and the worship of a superhuman controlling power, a personal god or gods. So if you're a Christian, a Muslim, Jewish, Buddhist, or Mormon, like whichever religion you follow, we cannot discriminate against you based on your inclusion with that religion. Now, religion also protects folks who do not believe in and or worship a superhuman controlling power or have a personal god or gods. So we can't say, oh, sorry, you're not religious, yet you can't live here. I'm going to discriminate against you. We can't do that. Okay? The next class is sex. And back in 1968 or 1974, when sex was added, it just meant whether you were male or female. However, there have been several changes to this class since 2014, and there is one more that's sitting out there that may actually have an effect on this class as well. So I'm going to walk you through each of the different changes that have occurred. The first one is Housing Notice H 2015-06. This was a notice issued by HUD which bars discrimination in HUD-assisted and HUD-insured housing based on a person's actual or perceived sexual orientation, gender identity, or marital status. I will tell you, I still hear today when I go out and do audits, managers who will tell a couple that if they are not married, they cannot share a bedroom. That would be a form of discrimination based on somebody's marital status. Because they are not married, we cannot tell them they can't share a bedroom. Or if you had two individuals who came into your office who were of the same sex, and they were looking for a one-bedroom apartment in a HUD-assisted property, we would not be able to reject them because they are of the same sex looking for an apartment, and we're assuming that they are gay or one of them could be transgender. We don't know. But this is just in HUD-assisted housing or HUD-insured housing that this rule affected, okay? And this came out back in 2015. However, a new court case has gone through, and this happened on June 15th of 2020. The Supreme Court determined that sexual orientation or gender identity is covered under the class of sex in the Civil Rights Act under Title VII of the Civil Rights Act. And that's the employment law under the Civil Rights Act. And this was Bostock versus Clayton County, Georgia. And if I remember correctly, this was a fellow who'd worked for a while with his company. And then it was found out that he was playing on a gay softball team. And once that became public knowledge at his office, they terminated his employment. He took him to court, and the Supreme Court last year decided that that is discrimination under the class of sex according to the Civil Rights Act, okay? Now, this ruling could lead to some further clarification that it also covers sexual orientation or gender identity in other areas, which would include education, healthcare, financial credit, or even housing. Because if they're going to include gender identity or sexual orientation under the class of sex in employment, it's very easy to see how that could be included in Title VIII, which is fair housing, Title IX, which is education. But that might take some lawsuits for that to go through, for that to be applied across the board. So the next step that's happened is on January 20th of 2021, President Biden signed Executive Order 13988. It was the Preventing and Combating Discrimination on the Basis of Gender Identity or Sexual Orientation. And what this executive order did was Biden ordered all federal agencies to review their policies to see if there were areas in which discrimination against gender identity or sexual orientation was occurring, and to bring their policies more in line with the Bostock versus Clayton County, Georgia. So Biden is taking a proactive approach and realizing that if the Supreme Court is going to enact that as part of sex in employment, it's likely that it's going to also include housing or education or other areas under the Civil Rights Act. So out of this executive order, on February 11th of 2021, the FHEO office issued a memorandum. In this memorandum, the Fair Housing Office has said that they shall accept for filing and investigate all complaints of sex discrimination because of gender identity or sexual orientation that meet other judicial requirements. So basically, all that's happened since 2014, we had a housing notice which pertained only to HUD-assisted properties or HUD-insured properties. Fast forwarding to 2021, where now the Fair Housing Office is going to apply that same philosophy to all housing covered under the Fair Housing Act. So we went from just HUD covered, HUD insured to now everybody other than those three exempt classes that we first talked about. Okay, so lots of changes have been happening in the area of sex protection under the Fair Housing Act and Civil Rights Act. And then the third thing that we need to be aware of is the Equality Act. The Equality Act was passed by the House and is now sitting with the Senate. Now, if this law is passed, it will actually amend the Civil Rights Act and the Fair Housing Act to explicitly prevent discrimination based on sexual orientation and gender identity. So remember I said when the executive order came out, the Fair Housing Office is now investigating that. This Equality Act would actually cement the rule and make it much more clear and clear up the patchwork of rules that are currently out there. So we just need to be watching for this. I've been trying to watch to see the status on this. As far as I know, it's still with the Senate. But if it does pass, it will actually add a new protected class to the Fair Housing Act. Well, currently we still just have 7. The Equality Act will add an 8th class. Okay, the next class to talk about that's protected is familial status. Familial status covers folks who have a child under the age of 18 in their household. Familial status does not refer to whether mom and dad are married or whether the head of households are married or not. It just simply refers to having a child under the age of 18 in the household. Now, this does cover women who are pregnant or expecting to have a child. It also covers people in the process of adopting or people who are gaining custody of children. So if you know that somebody comes in, they say, hey, I'm working on adopting my children, and you don't like having children at your property, you would not be able to discriminate against these folks because they are adopting. Now, there are some protections for projects under the Housing for Older Persons Act, and typically these are, I usually see this on tax credit properties where you can get extra points for your bid if you offer housing for older persons, which would mean all residents. You might set a rule where all residents must be 55 and older, or maybe you have the all residents must be 62 years of age and older. So if you are enforcing that HOPA rule on your property and you're under the HOPA Act, you would be protected against a claim of discrimination on familial status. Because of the program, you're not allowed to have children. Hopefully that makes sense. Some of you folks, like on the HUD property, in HUD's world, we're not allowed to actually reject families because they have a child under the age of 18. So if you're on a HUD project, you probably do not have the HOPA rule. You could have a HOPA where just like the head of household has to be 55 and older, or one person in the family has to be 55 and older, or 62 and older. But generally under a HUD housing, we're not allowed to reject families that have children under the age of 18. Okay. And the last protected class is disability. And disability covers individuals with a mental or physical impairment that substantially limits one or more of the major life activities. So some mental or physical impairments could be blindness, hearing or mobility impairment, HIV infection, alcoholism, drug addiction, chronic fatigue, a head injury, learning disabilities, or mental illness. Okay. Major life activities include walking, seeing, hearing, speaking, breathing, and working. Now, this just says it's including. That doesn't mean that's it. These are the only cases that are major life activities. There could be other major life activities they just don't include in the list here, okay? Now, we do need to know that current users of illegal controlled substances or persons convicted for illegal manufacture or distribution of a controlled substance, sex offenders, and juvenile offenders are not considered disabled by the Fair Housing Act. So if I'm in your office shooting up some cocaine, I would not be protected as a person with disability. Generally, we're thinking of an alcoholic or a drug user who's going through the 12-step program, going through a rehab project. They could be covered by disability. But if I'm currently using an illegal controlled substance, or if I'm making the illegal drugs and selling it on the street corner, that would not necessarily be covered under the Fair Housing Act. Now, with disability, not only does it cover people who actually have a disability, it also covers people who are regarded as having such an impairment. So if you had somebody show up into your office and they were slurring their speech and your Southern heart came out, you're like, bless their heart, they're touched in the head. That person automatically becomes covered under disability under the Fair Housing Act because you've now regarded them as having a mental disability. So you would not be able to discriminate against that person based on your thought that they might have a mental disability. So I may not actually be disabled. I might just have a real bad headache that day. And I'm slurring my speech a little bit because I'm trying not to, let the headache take me over. But as soon as you assume I'm disabled, then I am protected under that class. It also protects those who are living with or are associated with persons with disabilities. So you could actually have a resident living at your property whose friend or family member might be disabled. And if their friend or family member is in a wheelchair and you're afraid that that person might create more damage in your unit, you cannot discriminate against the applicant because their friend or family is disabled. Okay, so it also protects folks who are associated with persons with disabilities, or if my spouse has a disability, you could not discriminate against me because my spouse is disabled. Okay, so that's the 7 protected classes. Does anybody have questions regarding the 7 protected classes?
Sorry, Tim, I froze up there for a minute. We have one question in the chat box, going back to the HAPA rule. Any special rules, considerations for children visiting relatives in housing under the HAPA rule?
I'm not sure I understand what they're wanting to know. Generally, if they're just visiting, hopefully they're in and out. If you're thinking long-term visiting where they go beyond your company policy for what you allow a visitor in your property, that I think you would have to fall back on your company policy on what you do when you have an unauthorized occupant. Like you've stayed way over your 2-week limit that you're allowed to stay as a visitor. Now you're starting to move into occupant. Then you would need to fall back on your company policy on what you do with those.
So I think your explanation piqued a couple other questions. So along those same lines, Jeannie has, so I'm assuming that the tenant is having children visit and they're receiving complaints that the resident is having children visit and other tenants are not liking it. So if you have a tenant using illegal, oh, sorry, let's answer that one first.
So yeah, here's the thing. Discrimination can come not only from management, but it can also come from other residents. So if you have a family that has young children that come over and you're on a 62 and older HOPA property, your residents could actually be in violation of the Fair Housing Act if they discriminate against the person who has young children visiting. Definitely work with your supervisor or your 504 coordinator or your fair housing attorney with the appropriate steps to take in resolving that issue.
Okay, and then we have another question from Sheila. So if you have a tenant using illegal substances, they are not covered under fair housing.
They are not considered disabled under the Fair Housing Act. They might be protected under a different class, but they would not be considered disabled under the Fair Housing Act.
Okay. And another question from Tanya. If a person is born male but identifies as female, what would I put on the gender box on the certificate?
I would put the gender that the applicant or the tenant specifies that they are.
Okay, and vice versa, yes. Jennifer has a question. If a tenant has a mental disability and it is affecting the well-being and safety of other tenants, is that person still covered under the fair housing? Is it legal to non-renew?
Great question. Yes, they are still covered under the Fair Housing Act. However, the Fair Housing Act doesn't give a person in a protected class free rein to do whatever they want. They still have to abide by your lease and they still have to adhere to the rules and regulations. So if somebody is threatening the health, safety, or quiet enjoyment of the property, you would still handle that as a lease violation and enforce the lease. But again, work with your supervisor and an attorney before you start doing evictions. The thing with that, which we're going to talk about when we start talking about the prohibited actions, is some of this stuff. But if the person says, I need a reasonable accommodation because I am disabled, you may have to work with them and set up a plan that they can adhere to. And if they fail to adhere to that plan, you may then be able to terminate the lease for violating the agreement. But work with your attorney on that.
Okay, we got a couple more here. So this is a tax credit property question. So so a lot of tax credit properties are 55 and older, and they are going to obtain custody of a grandchild. Would that fall under fair housing?
Right. So again, if you are a property under the HOPA Act where every household member must be 55 and older, you would still apply your screening criteria like you normally would. So because you are covered under the HOPA Act for the 55 and older, if you have a household member who is not, you would treat them as you would for any household who had a 22-year-old versus a 5-year-old. You still have to qualify for the property. The thing is, you just can't make rules that discriminate based on that. And HOPA provides some protection against the familial status when under 55 doesn't qualify.
And then Bobby has a question. I think this is maybe in regards to like medical marijuana. So her question is, smoking marijuana on property is not protected under the fair housing and could be wrote up per policy, correct?
Ooh, that's a fun question. So while many states are now allowing recreational marijuana use, it is still a illegal drug according to federal law. Okay. If you're on a HUD property, the weird thing with HUD is HUD doesn't care if they smoke marijuana once they move in. They leave that up to the owner agent to create a policy on how they want to deal with that. What they say is you can't create a policy that prohibits you from evicting them, but you can allow it if you want, even on a HUD property. If your policy is no smoking and you put in there that smoking includes weed, cigarettes, vaping, or whatever, if they are violating that, you could still move to evict them.
Okay. Scroll down a little bit, a couple more questions. If a tenant has a disabled family member that visits frequently and they want their place to be ADA accessible, are we obligated to do that?
We're going to talk about that. That comes under a reasonable accommodation, but I'll give you the real quick answer, Cindy, yes. But we're going to talk more about reasonable accommodations and going through that as we go further.
Okay, and this might be, Miranda's question might be also addressed later, but if a person states that they are disabled, are we allowed to ask for proof?
Yep, we're going to talk about that later.
Okay. What about if it is for medical use? I think this goes back to the marijuana.
Right, so again, marijuana under the federal law is still an illegal substance. Even in the state of Kansas, it's an illegal substance. While some states may allow it, again, that it kind of goes back to your company policy. If you're in a state that allows medical marijuana use, and I'll be real honest, HUD and the federal government are not chasing down marijuana smokers. Just know that if you have a non-smoking policy, it doesn't matter that your state allows it. It's the Fair Housing Act is a federal law, and therefore, because marijuana is a federally illegal substance, it would not necessarily fall under the Fair Housing Act to grant that as a reasonable accommodation.
Okay. I haven't seen any other questions come in, so thanks, Tim.
Okay, moving on then. The next thing that we're going to talk about are some prohibited actions. Now, under the Fair Housing Act, it is illegal to discriminate on any of the following persons based on their inclusion in a protected class. So you cannot discriminate based on race, color, national origin, religion, sex, disability, or familial status. So here are the things that we cannot do. We cannot refuse to rent or sell housing to somebody based on their inclusion in one of the protected classes. So if you don't like children, you can't just refuse to rent to children unless you're one of the HOPA protected properties. If you don't like that some cultures use a lot of curry in their cooking, and you have a couple walk in and you can smell the curry on their clothes, you cannot just refuse to rent to them, okay? We also cannot refuse to negotiate for housing based on somebody's inclusion in one of the protected classes. We also cannot make housing otherwise unavailable. So just because I come in and I belong in a protected class which you don't like, you can't make the housing unavailable to me. We also cannot set different terms, conditions, or privileges based on our inclusion in a protected class. Some of the things that we see is individuals who are using oxygen tanks. You cannot require them to obtain a higher level of renter's insurance on your property than you would somebody who doesn't use oxygen. You also couldn't tell a family with children that they have to pay a higher security deposit for a unit than somebody without children going into a comparable unit. So we can't set different terms for them. We also cannot provide a person with different housing services or facilities. We cannot deny that housing is available for inspection, sale, or rental. And this might sometimes happen when you have somebody who makes a phone call and asks about that 2-bedroom apartment that they saw you have available. And then when they show up, you realize that, oh, that they have kids and I don't want kids here. So you tell them, oh, doggone it, that 2-bedroom apartment you called about this morning, yeah, I just rented it. Sorry. When in reality, that 2-bedroom apartment is actually still available. We also cannot make, print, or publish any notice, statement, or advertisement that includes a preference. And this gets a little bit tricky because sometimes we want to maybe point out some nearby attractions in the neighborhood. And so we want to put that in our print ad. So we might put in a statement such as, we're located next to the Christian church. Well, what that might do is indicate you have a preference for Christian families. Or you might say, we're located next to the Jewish synagogue. again, that would be maybe you have a preference for Jewish families. You can't do that. One of the other things that I see frequently is properties have very limited types of advertising that they do. And I usually see pictures of a couple in their property or sitting down, and it's usually a couple of elderly stature, and they tend to be white. So we're advertising our property to happy old white people, which could be a preference that you don't want children at the property, or that you don't want persons of color living at your property. So if you're going to use pictures of people, you need to make sure that the pictures encompass everybody from the different groups of our protected classes. So you want older, you want younger, you want people of color, you want white people, you want to have folks who are disabled versus folks who are not disabled. You want to make it as inclusive of all the protected classes as you can, okay? We also cannot impose different sell prices or rental charges. So if you know you have an applicant who comes in and they're in a wheelchair, and you know those wheelchairs damage the walls, you can't charge that household a higher rent than you would for a household who does not use a wheelchair, okay? Can't set different rental charges based on their inclusion. You also cannot use different qualification criteria or different applications. So you have to ask the same questions of every family that comes in to apply, regardless of whether they have kids or regardless of whether they are disabled. You can't ask them different questions. You also can't set different qualification criteria. So if you do a credit score, you can't say, well, most families only need a 500 credit score to live here. Unless you have disabled people living with you, then you have to have a 700 score. So you can't set different qualifications for different families. We also cannot evict a tenant or a tenant's guest based on their inclusion in a protected class, okay? So if you have that family that has children that come to visit them, you can't necessarily evict the tenant because they have children come visit them, just because they could be protected, right? You've got children coming to visit you, we can't kick you out, okay? We also cannot fail or delay to perform maintenance or repairs. So you've got that one tenant whose apartment smells like curry, and your maintenance guy just does not like the smell, so he puts off doing their work orders. He doesn't want to go in there because he just can't stand the smell. That would be a prohibited action. Hopefully you have a policy that shows, you know, when a work order comes in, we date and timestamp it, and they're completed in the order in which they were received. That helps make sure that you are not delaying repairs, okay? You cannot limit privileges, services, or facilities of a dwelling based on somebody's inclusion in a protected class. So if you've got a swimming pool in the back of your property, you can't say the adult hours are from 5 to 10 p.m. and the pool closes at 10. So that would limit the privileges of housing of families with children from using a facility at your property. So you can't have rules that discriminate. We also cannot discourage the purchase or rental of a dwelling. And I'm gonna give you a little personal story here. Back when I was a terrible fair housing nightmare for the company I worked for back in the beginning of my housing career, I actually had folks come in and they were looking to rent an apartment, and looking at them, I was on a tax credit property, so we had income limits, and I could tell that they were probably overqualified. So what did I do? Trying to be a kind-hearted person and saving them a $50 application fee, I told them, yeah, you guys probably aren't going to qualify, you don't want to apply. Like, I can't discourage the purchase or rental of a dwelling. And in this case, it was based on the sex because the applicants were both male and they wanted a one-bedroom apartment. And I was like, yeah, you don't want to rent here. I was trying to be kind and save them $50, but I can't do that. I can't let my heart get in the way and try to help them and discourage them from renting at my place. We also cannot assign a person to a particular building or section of a building. So if you have a high-rise building and you know that children on the upper floors like to stomp and run around and you get noise complaints from the neighbors below them, you can't say all children go on the first floor. Or you can't say all disabled individuals have to live close to the elevator. Another thing that I have seen is if you've got a playground, you can't say the families with children need to live near the playground on the property. Where the people go on the property depends, A, on where you have vacant units, and if you've got multiple vacant units, letting them choose where they want to be on the property. It's up to them to decide what fits their needs, not us, based on what we think their situation is. It is also prohibited for us to harass people based on their inclusion in a protected class. So if you know you've got a resident who loves to cook curry dishes, and honestly, when I go into buildings and I smell it, I love the smell of curry. I think I'm odd in that, but I like want them to invite me to lunch. But you cannot tell them, you know, you have to stop cooking that, and you can't harass them because they're cooking something with a strong smell. So be careful with that. Also, it's prohibited to do sexual harassment. So there's regular harassment, and then we have sexual harassment. And there are two types of sexual harassment. The first is quid pro quo, which means you're going to request or engage in sexual conduct as a condition of obtaining or maintaining their housing or housing related services. So if you got a maintenance guy who's out on the property, and I pick on the poor maintenance staff, but if he sees one of the residents and he thinks she's a hot looking lady, he cannot tell her or ask her to exchange maintenance services for a quickie down in the maintenance shop. Like, you come put out, I'll do your maintenance, I'll really hook you up. That would be sexual harassment under quid pro quo. You cannot do that. The other is hostile environment. So that's when a housing provider subjects a person to severe or pervasive, unwelcome sexual conduct that interferes with the sale, rental, terms, conditions, availability of housing, or housing related services, okay? So I may not be saying, hey, if you put out, I'll really hook you up on your apartment, get you a ceiling fan or whatever. It could just be that I'm making sexual passes toward you repeatedly, and they're unwanted by you. That would be a hostile environment situation. Now, there has been a court case out there where a tenant sued the management company for sexual harassment because the maintenance guy asked her out on a date. Now, the way that court case worked out was because the maintenance guy only asked her out once, but he didn't retaliate in any manner against her. Like, he still continued to do her maintenance in the order they were received. He didn't ask her out again. He didn't do anything else. Because it was a one-time thing, it was not considered severe or pervasive. Now, personally, as the manager, I would have had an issue with my maintenance guy asking a resident out because you just don't even want to cross that line. But just know that under hostile environment, it has to be severe or pervasive. A one-time got shut down and I'm done with it, that wouldn't necessarily fall under hostile environment. I am not advocating to ask your residents out, not by any means, just don't do it, okay? It is also prohibited to threaten, coerce, intimidate, or interfere with anyone exercising a fair housing right or assisting others who exercise that right. And I'm going to do this next point, which is we also cannot retaliate against a person who has filed a fair housing complaint or assisted in a fair housing investigation. So what happens is that sometimes the tenant will go right to the fair housing office without talking to us. They file a complaint and we win that. Like, they can't prove that we discriminated against them. Good for us. But then what we do is we want to teach them a lesson. So then we start withholding their maintenance. We start harassing them, trying to get rid of them because they've made us mad. So it's not unusual for owner agents to win that first discrimination case, but then get sued again because they've retaliated, and then they lose the retaliation case. So just know, everybody has a right to file a claim. Let them file a claim. Let them get their attorney. My philosophy is, I've got an attorney too. Go ahead. It's fine. Just don't retaliate against them. About 10-ish years ago, there was a case in Kansas City, Kansas, where the manager and her son, who was the maintenance guy, were harassing residents at the property. And the service coordinator at the property assisted the resident in filing a fair housing claim against the manager and her son. So then the manager, her son, and management company ended up firing the service coordinator for assisting that resident in filing that claim. So then the fair housing, or the service coordinator, filed a complaint and a lawsuit. Ended up the manager was enjoined from ever working in housing. So the manager of that property can never be a property manager again. There were also several $1,000s in claims that arose out of that court case because she retaliated against the service provider from doing her job. So please do not do that. Okay. So now, y'all, I'm going to give y'all some just my fair housing suggestions. Okay. My first suggestion is that you leave your own personal opinions about people and things, your own moral opinions, and your emotions at the door. Because what a lot of the time, what happens is we try to help our residents, we try to help applicants, and we think we're doing what's best for them, and we're trying to do it out of a good place in our heart. But that's when we start violating the fair housing laws. So leave your opinions, your own personal opinions, your moral opinions, and emotions at the door. What I always tell people to do is when you come to the office, you pluck your little heart out of your chest, you set it on the stoop, you go in and do your job and follow your company policies. And then when you leave, you pick your little heart up off the stoop and you plug it back into your chest. When you're at work, you follow your company policies. It's not about you when people have the issues. It feels personal, I understand that, but we really need to do our best to stay neutral and treat everybody fairly and the same, okay? And again, always, always, always follow your company policy. Okay, do we have any questions over the prohibited actions?
Yes, we have a couple. We might go over this one when we talk about assistance animals, so I'll ask the question. If we need to hold off on answering, we will. What if your insurance company requires liability insurance for a certain breed of dog, and that dog happens to be a service animal? If you require all pets and service animals, regardless of breed, do you have this liability insurance? Breed to have this liability insurance, are you in compliance?
We'll talk about service animals at the end, so if I don't answer the question, then repost it.
Okay. And then this is regarding a wheelchair and damage to the property. If we have a resident that causes damage to the wall with their wheelchair, is it against fair housing to charge them for the damage?
No, residents are still bound to follow the lease, and if they cause damage to the unit, they're still liable for paying for the damages.
Okay. And then Bobby has a question about someone who wants to burn incense or candles or sage in their unit. We are not able to tell tenants to stop doing that, correct?
That's a company policy decision. I know I live in an apartment where they ban burning candles and incense just because it's a fire hazard, apparently. So really, that's more of a management decision, not a fair housing issue.
Okay. And then I'm going to flag this one. Jan has a question. Oops. Oh, scroll back down. If a person is arrested for a felony in an event that happened off the property, can the resident be evicted?
Talk to your legal counsel on that. That's not really a fair housing issue. That's more of a lease issue.
Okay. We have another question up here that was pertained to the first part of the training. Serenity asked a question about if there was any specific HUD rules on smoking on the property, or is that just up to the management owner? And she's not just talking about smoking, just smoking in general and not just marijuana.
Yeah, there are some guides on HUD's website regarding smoking in units. HUD recommends that you go smoke-free. It's not a requirement on a HUD property to be smoke-free. But then if you do set up a non-smoking policy at your building, you do need to designate a smoking area for the residents, and you just need to tell them where that is. But if you're going to do like distance from buildings, that probably fall more under your local code. So you want to check that as well.
Okay. And I think that's all the questions we have right now.
All right. So the next thing we're going to talk about are reasonable accommodations, and I think some of the questions we might have passed we'll pick up here. So reasonable accommodations. An accommodation is a change, exception, or adjustment to a rule, policy, practice, or service that may be necessary for a person with a disability to have an equal opportunity to use and enjoy a dwelling, including your public and common use spaces, okay? That could include something as allowing applications to be mailed to your office when your policy says all applications must be hand delivered, so we can see you, make sure we have all the right paperwork. You may have to allow a person with disabilities to mail that paperwork to your office. It could also be that you have to allow someone else to assist with completing their paperwork. If I am a disabled individual, I may need a guardian or somebody to assist me with doing any research paperwork or signing the lease or things like that. And then the ever most present one is if you have a no pet policy on your property, we would have to allow a service animal, okay? For a modification, this is also a reasonable accommodation, but the modification is when we make a structural change to an existing premises occupied or to be occupied by a person with a disability in order to afford that person to full enjoyment of the premises. So an accommodation is a policy, a modification is a structural change. So modifications could be adding grab bars to the bathroom, maybe widening doors for accessibility or lowering our countertops for accessibility. Okay. Please know that a reasonable accommodation request can be made by a disabled individual, the actual disabled individual themselves. It could be by someone on behalf of the disabled individual or by someone associated with a person with disabilities, okay? So remember when I talked about you have the applicant whose family member might be in a wheelchair, the applicant or your tenant who does not have a disability may request a reasonable accommodation on behalf of that family member or friend who comes to visit them. I mean, they could ask you to add grab bars to the bathroom around the toilet to help that disabled individual better use the facility. So just know that they can also request a reasonable accommodation. Now, when they make the request, they do not have to use the term reasonable accommodation. So if I came in and said, hey, could you add some grab bars or bars around the toilet so that my mom who comes to visit me is able to stand up, we can't say, oh, you didn't say reasonable accommodation, too bad for you. They do not have to use that term, okay? Now, people may request a reasonable accommodation during their application process. However, they're not required to disclose it during that time. It may actually be that they make the request during tenancy, or it could be during their termination when you're terminating them and all of a sudden, hey, I've got a disability, I need a reasonable accommodation. So it could come at any time, whether or not they've actually disclosed that disability or not. So if on the application I don't disclose that I'm disabled, but later in tenancy, I ask for that grab bar, well, you know, you didn't tell me at application you're disabled, Tim. I'm just not able to do that for you now. It doesn't really matter whether I disclose the disability at application or not. So just know those can come at any time. So what do we need to do when someone requests an accommodation or a modification? The first thing we want to do is document the request. Now, we are not able to require that the person making the request put it in writing. So if they don't put it in writing, what I recommend doing is you put it in writing. You write down what they are requesting so that you know exactly what it is. The next thing I recommend is submitting it to your 504 coordinator if you have one. If not, submit it to your supervisor. If you are at the top of the line, I would definitely make sure reach out to a fair housing attorney if you have any questions about what to do. The next thing that we would do is determine whether to grant the accommodation or modification. And then if we do grant it or we do not, the important thing to do is maintain a log of all requests and all the outcomes. So I would make sure you log the date and time you received it, who sent it in, what they wanted, and what you did, when you did it, and when the accommodation was completed. Just make sure you have a log, because if somebody files a fair housing claim against you, you have a quick, easy reference of, look, here are all the accommodations we've had. Here's the things that we did. Show that you are in compliance with the fair housing law and doing reasonable accommodations. I would definitely keep a log. So what do we need to know when processing a reasonable accommodation? The first thing we have to know is, are they disabled? Do they have a mental or physical impairment that substantially limits one or more of life's major activities? Remember, walking, talking, seeing, breathing, things like that. Now, you may request documentation to show that the tenant is disabled, okay? However, you cannot require any other information that regards the disability. So you really want to know, do they have a physical or mental disability which limits one or more of life's major activities? That's really all you need to know. We don't need to know the nature of their disability or how severe that disability is. We don't care. It's irrelevant to determining whether they need a reasonable accommodation. Now, we are allowed to confirm information from a healthcare professional, such as their physician, an optometrist, psychologist, nurse practitioner, a nurse, or a physician's assistant. Okay, so you can confirm that unless that disability is obvious or readily apparent. So if you know that they're receiving disability benefits like Social Security disability, they're disabled. If they're receiving SSI under the age of 65, they're a disabled individual. If they're receiving veterans disability benefits, they're disabled. If they're getting state or local disability benefits, they qualify as disabled. Okay, so if I've got information that tells me that they are already disabled, I do not need to confirm it with the healthcare professional. Also, if the disability is visually apparent, so if I see you come in and you're using a wheelchair, or you're missing your arms and your legs, or if I know you're deaf, or I can tell that you're blind, I do not need to verify that you are a person with a disability. It's readily apparent, okay? So if I come in, it's not readily apparent, and you don't know that I'm disabled, you can confirm with the healthcare professional. If you can tell or you already know, please do not do that. Next thing we need to know is what the accommodation being requested is. So they should be able to come in and tell you, hey, I need a seeing eye dog. That one's generally pretty obvious, so great. But I may come in and tell you, hey, I need grab bars in the bathroom. Great, now I know what the accommodation is. The next thing that we need to know is if that accommodation is related to the disability. Okay, you can confirm with the healthcare professional that what they're asking for is tied to their disability. So if I were to come in and I am deaf and I ask for grab bars in the bathroom, It's not really obvious to me. I don't know how grab bars are tied to deafness. So what I can do is I can confirm with a healthcare professional that they actually need grab bars in the bathroom. Okay. Now, again, we cannot verify this information if that nexus or that relationship is obvious or readily apparent. So if I'm a deaf person and I come into your office and I say, hey, I need a flashing smoke detector because I can't hear the beep when it goes off, but I can see the flash. Well, that's pretty obvious that those two things are related. You do not need to confirm that information with a healthcare professional. Okay. Now, if you have the information that affirms that they are disabled and there is information to show there is a nexus between the accommodation, you have to approve the reasonable accommodation. Yep, you need it, you get to have it. You can offer an equally effective alternative. So instead of rehabbing somebody's unit by lowering their counters and widening their doors and adding grab bars to the bathroom, you could offer to transfer them to a unit that would meet their needs. So if you've already got a unit with lowered counters, you've got widened doors and grab bars, you can transfer them to that unit instead of making the changes to their current unit. Okay. The thing that we all need to be very cautious of and aware of is that 60% of Fair Housing Act complaints are related to the denial of reasonable accommodations and disability access. And most of these denials involve when the disability is not readily apparent. So what happens is somebody comes in and asks for reasonable accommodation and we just think they're kind of full of it and we don't do it. Those are the complaints that get filed with HUD, okay? Know that you do not have to make a structural change when other methods are effective in achieving compliance. So you don't have to lower the countertops when I can move you to a different unit that already has those lowered countertops. I don't have to widen the door when I've already got a unit that has widened doors, okay? We are also not required to make alterations that have little likelihood of being accomplished without removing or altering a load-bearing structural member. So if you have a resident that comes in and wants widened doors, but to widen the door between the bedroom and the living room would require altering a load-bearing wall in your building, you would not have to make that accommodation, okay? You also do not have to make mechanical rooms and other spaces accessible when, because of their intended use, they do not require accessibility by the public, by tenants, or by employees with physical disabilities, okay? And finally, we do not have to install elevators solely for the purpose of making units accessible, okay? So if somebody wants to live on the second floor, but all you have are stairs at your property, you do not have to build them an elevator to get them to the second floor. Or if I live on the second floor and I have visitors in wheelchairs, I do not need to build them an elevator so they can get up to my apartment to visit me, okay? So with reasonable accommodations, we need to know that they are disabled. We need to know that there is a nexus between what they're asking for in terms of an accommodation and that disability, and we can verify that information unless it is readily apparent or already known, okay? Any questions about reasonable accommodations?
Yes, we have some. Going back to the application process, there's a question by Arnold. Is illiteracy covered under fair housing? If someone is illiterate, do we have to read all their paperwork to them, or do they need to find someone outside the agency to do that?
Well, literacy, that one's kind of steep, because if it is somebody with limited English proficiency and they just don't read English, you would need to probably make the document available in a language that they can read. If you're on a HUD property, we are bound by the LEP requirements of translating documents for individuals who do not read or speak in English. If it's just a general person who doesn't read and they speak English but they don't read, just a Jew, I would read it for them, because honestly, why not assist somebody to get them in? The object is to fill your units. So I would definitely do what I could to get them into my apartment. That would be what I would suggest. Again, reasonable accommodation deals with disability, and I don't know that being able to read would constitute a disability in terms of the Fair Housing Act. But I think that one I would definitely contact a fair housing attorney just to make sure.
And then along those same lines about translating policies and documents into the tenant's native language, if there's a cost incurred, who assumes that cost?
That's really not necessarily covered under the, it's not really covered under the Fair Housing Act, because speaking a different language is not really a disability, right? Unless it's a disability, then it depends. And we're going to talk a little bit more about who pays for accommodations when we talk about 504, which is next.
Okay,
but
well,
I'll tell you what, I was on site, our company paid for the translating of documents, because then we can use that document over and over for anybody that comes in who may speak that language.
okay, and then we do have a couple questions about like who's paying for the reasonable accommodation, like grad bars and things like that, so we can
That'll come under 504.
be on that. Let me see. And then we have another couple pet ones I'm going to hold off on. If a person is on oxygen, is that considered a disability?
If they claim that they have a disability, and to me, that would be that they have difficulty in breathing, I would say that would probably fall under the disability mantra of major life activities: hearing, seeing, breathing, walking.
And then we have a couple questions regarding unit transfers. So if there's someone with a disability that can transfer to a unit that's already in accommodation for that person, what if they refuse to transfer?
If they refuse to transfer, yeah, so that's where it gets really difficult, is when the tenant makes an accommodation request and they will not accept anything other than what they've actually requested, but you're able to offer them something equally effective. They can't just outright refuse to make some change. You would want to have a continuing dialogue with them. We're going to talk a little bit more about that in section 504 in terms of what we have to do. But you can't ever say, oh, they didn't take my suggestion and I'm done with them. Like, you can't do that. But on the flip side, they shouldn't be like, you're not doing what I want, I'm going to be stubborn.
Okay. A couple more, excuse me. If applicant is next on the waiting list and you offer an available apartment, and then they not get over a tub, take a shower, and need a shower only more than 3 inches step, I think they're asking, are they required to make that?
Oh, Jackie, you're freezing up.
Testing. Can you hear me now? Can you see me?
Now I can, yeah.
Okay, sorry. Mike had a question about, a waiting list, an applicant on a waiting list. And if you offer in a unit and it's a unit with a tub, and the person tells you they can't step over a tub, they can only take a shower, it's to be a 3-inch step. Do they need to make that modification, or do we just need to wait until that unit is available?
So if you've got an accessible unit with either a low step-in tub, here's what you would do. You would probably need to move them into a unit that has a regular tub, or give them the option to accept the non-accessible tub unit and put them on a wait list to a unit that would meet their needs. Or you could make the modification to that unit if you chose. But you would not want to skip them without them saying skip me. You need to offer them the unit first. And then they can either move to a unit that fits their needs, or they can choose to stay on the list until that unit comes available.
And this is, I think you might, I just want to clarify with another question. If you only have non-handicap accessible apartments available for rent, but a handicapped person is applying for a handicap unit, are you required to modify the unit or keep them on the list? I think that's
right. So when somebody comes in with a reasonable accommodation, if they need that accommodation and it's verified that they have that need, you would need to make the modifications. We're going to talk a little bit more about that when we talk about 504. There's a few follow-up questions, but that'll be covered in 504.
Yep, and there's a couple more, so I'm going to skip over a couple regarding who pays for the accommodation. If a modification could potentially damage equipment, would this request need to be approved? They give an example. Tenant requested a HEPA furnace filter that is not recommended by the manufacturer.
Right, and we'll talk a little more about kind of what we need to do. You can't just say we're not going to make that accommodation. You would need to make a modification that you could. So maybe find out from the manufacturer if there are any HEPA filters that would work for that furnace. And if there aren't any, then work with that resident to find out another workable solution.
Okay.
Always do that in consultation with your attorney.
And then our last one, if a tenant on the second floor of an apartment building becomes permanently disabled and is now required to use a wheelchair, what is the property management required to do to accommodate their new mobility needs?
Right. Well, again, it would go back to the reasonable accommodation. They would have to request what their needs are. So if they need grab bars, they need to come to you and request, I need grab bars. If they needed any mobility features or something modified or changed in their unit, they need to come and make that request of you. Don't just assume what they need and start doing it on your own. Let them come tell you what they need, and then you'd walk through that process. Are they disabled? What is the accommodation, and is there a nexus between what they want and their disability? And if there is a nexus and you do know they're disabled, then you would need to start working to make those accommodations.
Okay, thank you. We'll save some of these other 504 ones for your next session.
Yeah. Okay, so the next section is Section 504 of the Rehabilitation Act of 1973. And what Section 504 tells us is that no otherwise qualified individual with a disability in the United States shall, solely by reason of his or her disability, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance, or any program or activity conducted by any executive agency or by the U.S. Postal Service. So Section 504 affects the post office, it affects schools, it affects airports, and it affects federally assisted housing. Section 8 properties, whether it's the PHA or a private owner, RD, home properties, etc. So if you're a conventional property, you don't have any HUD assistance or any federal assistance on your property, or if you're just a straight tax credit property with no layering of home on your property or no Section 8 on your property, you are not subject to Section 504 of the Rehabilitation Act in 1973. What Section 504 tells us is that we cannot offer different or separate housing at our properties based on somebody having a disability. We also need to ensure that our policies and procedures do not discriminate based on disability. And we had to create a transition plan to ensure that structural changes are properly implemented to meet program accessibility requirements. Section 504 also affects how we assign accessible units. So for the HUD properties, home properties RD, we have to take a current resident with the disability. If they need the unit, accessible unit, we have to offer them the unit first. If I don't have any current residents with disabilities needing an accessible unit, I must then offer it to an applicant with disabilities. This may mean I am skipping applicants on my wait list to find an applicant with disabilities who need the accessible unit. Now, if I don't have a current resident or any applicants with disabilities who need an accessible unit, I can then offer it to any other tenant or applicant based on my tenant selection plan. Now, if I'm going to offer an accessible unit to a tenant or an applicant who does not need the accessible unit, the features of that unit, the lease should require them to move if a disabled household does need the unit. So if I have an applicant who applies who needs the accessible features, when that unit or when they come onto the wait list and I know they need the accessible features, I should have a lease addendum that tells the household in the accessible unit that they need to move so that I can move that applicant in. Or if another resident becomes disabled, they might need to move down to that unit and the first family would need to move out of the accessible unit. Your lease addendum should also spell out who's going to pay for that move. So if I moved into an accessible unit that I didn't need the features of, because I didn't want to wait any longer to get to your beautiful property, I would have to sign that lease addendum, and that lease addendum should tell me whether I am paying to move myself out or whether management's going to pay for it. Okay. Now for the family moving in, if it's a current resident moving to that unit, we're going to talk about that in just a second. But the family that's not disabled, that does not need the accessible features, they may need to pay to move themselves out. Section 504 also affects our communications, our marketing, and our outreach. We have to take steps to ensure that our communications with individuals with disabilities is as effective as communication with individuals without disabilities. And I'll be honest, even if you're not covered by Section 504, I really think this is great for everybody, even our conventional, even our tax credit without layering. We need to make sure we're reaching out to everybody effectively, whether they have a disability or not. So this would apply to all oral, written, audible, visual, or electronic communications. So when we're working, we might call a resident. Well, if our resident is deaf, they aren't going to be able to hear the phone. How are we communicating with them? Maybe we're sending an email. But if I have a blind applicant or a blind tenant, they're not going to be able to read that email so well. Or if I'm conducting an interview or having a meeting with residents or doing trainings, how am I effectively communicating with persons who may be visually impaired or hearing impaired? Also, when we send out our notices, most of the time we send out our notices in writing. But if you have a blind individual, how are they reading your lease violations or your recertification notices, pest control notices, the inspection, or even your lease addendums? We have to make sure that we are communicating effectively with those individuals, okay? So this might mean that we need to have interpreters come to our tenant meetings to communicate with individuals with disabilities. We might need to employ computer-assisted real-time transcription. So when I'm typing, it's reading to the tenant on the other end what I'm typing to them, or what they're saying gets typed into me. Maybe we need to use captioned videos or a visual alarm device like the smoke detectors with flash for our hearing impaired tenants. Maybe we have talking thermostats installed to help our blind residents. Perhaps we're using Braille or large print, or maybe we just need to sit down and read the forms for them if they can't read it. Also, when we're doing telephone communication, there's the star 711 service, which is sort of like a blind individual will type in their communication through a relay center who then reads the communication. And then when we talk back to the communication person, they're typing our message back to the blind individual. Okay, so we have to make sure that we are effectively communicating with individuals with disabilities. Section 504 also requires that owners, managing entities, or projects that employ 15 or more employees have a Section 504 coordinator. This is the person who's responsible for ensuring that we are treating individuals with disabilities in a fair and consistent manner and making the reasonable accommodations and modifications in a fair and consistent manner. If you have any fact sheets, brochures, notices, literature, or any publicity of any kind, it must contain the name or the position of the 504 coordinator, their address, and a telephone number to reach them. Okay? Now, when we talk about reasonable accommodations and modifications, Section 504 plays a role in this. Under the Fair Housing Act, so properties like straight tax credit without layering or a conventional property, the tenant or someone on the tenant's behalf pays the cost for the modifications. So if I'm on a conventional property and I need grab bars added to the unit, I need to put my request into management. We need to go through our process of confirming the accommodation. And if we say, yep, that's fine, you can install the grab bars, the tenant or someone on the tenant's behalf would pay for that, okay? However, under Section 504, the owner shoulders the burden of paying for that accommodation. So when a tenant comes in and says, hey, I need my cabinets lowered 6 inches so that I can reach the cabinet, the ownership would pay for that modification, okay? Now, the owners are required to pay for the accommodation modifications unless that creates an undue financial or administrative burden, or it fundamentally alters the nature of the project. So if a tenant were to come in and tell you, hey, I need you to walk my service animal because I can't do it, well, our project does not offer dog walking services. That would be altering the nature of my project. I do not have to go and walk their service animal. Some of the other things you see is like on an elderly property, I need live-in care attendants, or I need somebody to come and take care of some household needs for me. And if I put in a reasonable accommodation for that, management would not have to be the one to do it because that's an alteration to the nature of our project. We are not a skilled nursing facility. We are not assisted living. It's just a straight apartment community. You can get somebody, a live-in aide or some caregivers to come in and assist you, but I wouldn't have to pay for those caregivers to come in either. Now, when we talk about the undue financial and administrative burden, if the project cannot afford to make the accommodation or it's an administrative burden, we do not have to do it. But we have to evaluate each request separately. So if a tenant came in with 20 different things that they needed done in their unit, I would need to evaluate each item on the list to make sure I can do it and that it is not an undue financial or administrative burden. And I must make accommodations or modifications up until it does become an undue financial or administrative burden. So if a tenant came in and said, hey, I need grab bars in the bathtub, grab bars around the toilet, and I need you to lower the cabinets by 6 inches, and I don't have an accessible unit on the project, I would need to look first at the grab bars. Can I afford to do the grab bars? Yep. Can I afford to do the handrails around the toilet? Yep, I can afford to do that. Can I afford to lower the cabinets? Ugh, wait a minute, now my budget is stretched. I cannot afford to do that. I would need to make the first 2 accommodations, but I would not have to do the last one of lowering the cabinets, okay? However, that doesn't let me off the hook. I need to have an interactive conversation with that household so that I can provide an accommodation or modification that I can make instead of lowering the cabinets, okay? It is not acceptable for us just to say, too bad, and wash your hands of it. You know, you wanted that HEPA filter in there, I can't put it in there, too bad for you. We can't do that. We do need to work with the residents up until the point that we cannot make that accommodation. And even on a conventional property, you need to be having that same conversation. If they want you to put in a furnace filter that doesn't work for your machine, okay, well, that doesn't work, but what can work for you? What alternative will work for you? And maybe you approve something else for them that's equally effective. Okay, so Section 504 affects federally assisted projects and how we outreach, communicate with residents, and who pays for the reasonable modifications to the property. Any questions on Section 504?
Okay, yes, we've got several, but I think you've answered some, so I might just scroll through here really quick and make sure. So again, if it is a modification like a grab bar, the cost that they need, the cost they need it for the guest. If they need, do they need to pay for it if it's for a guest? I'm guessing.
If you are covered under Section 504, you have to pay for the reasonable modification, even if it's for the guest of a resident, because you are under the Section 504 umbrella, we pay for the accommodation modification.
Okay. Then I think that that's a lot of the questions we have is who pays. Here's the one that kind of goes back to maybe your previous session section. If there is a tenant that is going deaf and received a formal noise complaint, is that an issue with fair housing if they have signed a policy that states a certain noise and timeframes that those need to be adhered to?
Right. Again, even though I'm a person with disabilities, I am required to adhere to the lease. Now, if I am making too much noise in my apartment and I'm deaf, you need to do your steps in addressing the issue. Now, it's up to the resident to say, hey, because of my disability, I need this accommodation so that I can stay in compliance with the lease. So they need to take a step to help ensure that they comply with the lease. Just being loud is, because I'm deaf, that's not necessarily protected under fair housing, but I might need to adjust my policies to ensure that they have the ability to make a change so that they can comply. Just being noisy and deaf is, you're not protected. You don't, it's not a free for all just because I have a disability. I still have to follow the lease. I still have to adhere to the rules. But if I'm struggling and meeting the rules, then I need to request an accommodation, and we go through that process of determining whether that accommodation should be approved.
And then we have a couple of these questions come up a couple times. If we have several tenants requesting designated parking spots, can we limit how many spots per household?
Parking is probably the second biggest pain to our existence after service animals. Honestly, every accommodation needs to be handled in the same manner. If your policy is one parking spot per person and both of the individuals in a household are disabled and they need designated parking closer to the front door, you would probably need to grant both accommodation requests. It's a modification to your policy to enable them equal enjoyment to the property. Again, work with your supervisor, work with your fair housing attorney to make sure you're complying, but I would say you probably would not be able to limit the number of parking spaces.
Okay, thank you. What kind of documentation do we need to keep that would show the undue hardship?
I don't have any concrete, here's what you must have to show that it's an undue financial burden, and therefore you don't have to pay for that 504 accommodation. but you definitely are going to have to review your budget, your profit loss. You're going to have to do a lot of research to show that you can't. The question is if fair housing comes in and says, why did you refuse this accommodation modification? And you say it's a financial burden, how are you going to prove that? Like, you need to go through your budget, you need to go through your expenses, what's the current financial standing of this property? You would need to be able to answer the questions that they asked to prove that it was a financial burden.
Okay. Let's see. Actually, I have a couple ones I'm getting some clarification on, so I'm going to skip those for now. This has come up a couple times. If you are a non-smoking property and have a disabled tenant request to smoke in their unit, can we deny?
Yeah, HUD has issued some guidance on that. Basically, smokers are not a protected class. So you are not required to allow them to smoke in their unit. You may need to make an accommodation for where they can smoke if their path or they are like super far away from your designated smoking area. You might need to make an accommodation as to where they can smoke that might be closer to their unit, especially if they have a mobility issue. But HUD has said that you do not have to grant them the ability to smoke in the unit. So there's that.
Okay, and then I have a couple questions specifically about Section 504 that I thought you would just kind of clarify again. Section 504 only applies to federally funded properties?
That's correct. Section 504 is federally funded properties. So if you are a straight tax credit property and you don't have home or RD or Section 8 layered on top of it, just a straight tax credit, you are not bound by 504. Even though you're required to accept the tenant choice voucher, but that is the tenant benefiting from the federal assistance, not the property. They're just paying rent for you. If you're in a HUD contract, a project-based Section 8 building, because you are the recipient of the federal assistance, you have the contract with HUD, you are covered. But just a straight tax credit, even though you take the tenant choice voucher, no, you are not.
Okay, and I get a couple of never mind, my questions were answered.
I like when that happens.
Yeah. And some of these I think are specific that we will have to respond to directly after your presentation. I'm trying to get some general ones.
Rachel. So Rachel's question is, for a straight conventional property, we are not required to make any reasonable accommodations when asked of us. To be clear, you don't have to pay for the accommodations or the modifications. You still have to grant them if they are a person with disabilities and there is a direct nexus between what they need and that disability. So you've got to go through that process. And if they are disabled and what they need is directly tied to that disability, you have to allow the accommodation or the modification. Okay, so on a straight conventional property, you still have to allow it. You just don't have to pay for the grab bars in the bathroom. You still have to allow them to put them up.
Okay. And she says, thank you.
Yeah, and there are some additional criteria when tenants are paying for reasonable modifications and accommodations that we didn't get into, just because it would add a little bit too much time. But there are things that go into that when they are paying for their modifications. So make sure you reach out to your supervisor or your fair housing attorney before they start constructing, so you know what your rights are in terms of them making modifications.
Okay. I think that's it.
Okay, we got about 20 minutes left here, and we have assistance animals left. But like Jackie said, if we don't answer your questions here, they're gonna send them to me at the end, and I will respond to you. within the next week or so. So don't panic if I don't get to your question. But we're going to move into the assistance animals, which is our last section. And this is everybody's favorite topic. So ultimately, the first question is, what is the #1 rule related to assistance animals? And hopefully everybody said assistance animals are not pets. We need to not refer to them as pets. We really should practice calling them assistance animals or just calling them an animal when we discuss them. Because if you're calling them a pet, then we start getting confused with what is actually a pet. And they really are two separate classes. So when we're talking about assistance animals, call them an assistance animal or call them an animal. Just don't call them a pet. If you're a HUD property and the PBCA comes out and audits you and you call them pets, that just raises all sorts of red flags in our heads and it gets real messy and we just don't want to do that. So assistance animal or animal is what we're going to be talking about. So with assistance animals, there are two sets of laws that we need to keep in mind. First off is the Americans with Disabilities Act, or the ADA, and the Fair Housing Act. So under the ADA, that generally covers public facilities, public and common areas and buildings. So in our properties, we're talking about the office, our model that we show prospective tenants, the grounds around, like the parking lot, anywhere that we would take people from the general public or areas that are available to the general public on our property. When we get into the Fair Housing Act and assistance animals, we're talking about our tenants' units, our residents, our community room for our residents. If we have a little library for our residents, we're talking about those areas. So there are two different rules that we comply with here. So this is also another area where HUD has been very active. Back on January 28th of 2020, the Fair Housing Office issued FHEO Notice 2020-01. This one actually replaced Housing Notice 2013-01, and it applies to all housing providers covered by the Fair Housing Act. So while 504 was just federally assisted properties, this Fair Housing Notice covers everybody covered by the Fair Housing Act. Please remember that requests for assistance animals can come before or after the person gets the animal. It can come before or after you seek termination of the lease. So if you see a resident that has an animal, they haven't reported to you, so you issue a lease violation notice for an unauthorized pet, they can come into you and say, hey, look, I need this animal for a disability. Ugh, great. Please know that it can come after you issue that lease termination notice. Now, when we talk about assistance animals, there are two types of animals that we talk about. The first one is a service animal, and that was the one that falls under the ADA requirement. And then we have other animals that do work, perform tasks, provide assistance, and or provide therapeutic emotional support for individuals with disabilities. Let's talk about service animals first. Under the ADA, a service animal means any dog that is individually trained to do work or perform tasks for the benefit of an individual with a disability. Service animals are dogs, okay? Now, there are some separate provisions out there for miniature horses. I'm not getting into that because hopefully our properties aren't experiencing too many miniature horses. There are some rules involved with that, but if you read the housing notice, which is attached, was one of the attachments that we gave you for this training, there are some provisions listed in there. I think it's in the, actually it's in the FAQs for assistance animals, so look in there. So when we talk about assistance animals and service animals, we need to ask some questions. So with service animals, the first question we have to ask is the animal a dog? If it's not, it is not a service animal, but it may be another type of assistance animal for which a reasonable accommodation is needed. So if it's not a dog, that doesn't mean we're done quite yet, okay? The next question we ask is it readily apparent that the dog is trained to do work or to perform tasks for the benefit of a person with disabilities? If no, we're going to ask these next questions, but if yes, great. If it's not readily apparent, we need to ask, is the animal required because of a disability? And we need to know what work or task has the animal been trained to perform. So again, if they say yes, and the work task is identified, so yep, it's been trained and here's what it does, it's a service animal. If they say no, it's not been trained, or nope, it doesn't provide any service to me, it is not a service animal under federal law, but it might be a support or other type of assistance animal that we still need to make an accommodation for, okay? So other animals, assistance animals, therapy animals, and emotional support animals. And at our properties, this is probably 99.99% of what we deal with. So there are some things that we need to walk through in order to determine whether we grant this assistance animal, okay? The first is, has the individual requested a reasonable accommodation? If they haven't, they need to. If they haven't, I'm not going to grant an accommodation that's not been requested, okay? So if they have, does this person have an observable disability, or do I already know that they are disabled? So remember, when I'm thinking about verifying, I'm going to look, do I already know that they're disabled? Do they get SSDI? Do they get SSI and under 65? Are they receiving veterans disability benefits? Remember all that? This is, do we already have that information? Or if I can tell that they have no arms and no legs and they're in a wheelchair, it's pretty observable that they have a disability. Those are things that we need to ask. If it's not readily apparent or I don't have information, are they providing it to me? Have they given this information to me? Do they have it in hand? If not, we're not required to provide that reasonable accommodation, but we must give them the opportunity to go get it, to provide us with that information. And what you want to do is direct them to the guidance on documenting an individual's need for assistance animals and housing. And that one is a part of the 2020-01 notice, which was included in your handouts, okay? So if they come in, we need to know that they are disabled and that they need the animal. And again, it's like a reasonable accommodation. If it's readily apparent or known that they're disabled and there's a connection, then we know we'll need to grant that, okay? So if it is, they are disabled. Yep, you've got the information, you know I'm disabled, and you know there's an animal. We need to know if that person requesting the accommodation provided information that supports that the animal does work or provides a task or does some assistance or therapy for that individual, okay? So if you know I'm disabled and I need that animal. If no, you're not required to grant that accommodation, but you have to give them the opportunity to go get it. So we're okay. If they say yes, so yes, we know that I am a person with disability, and yes, that animal provides a task for me. Then I need to ask if that animal is commonly kept in the household. So a commonly kept animal, notice it's not a pet, I'm calling it, it's an animal, would be a dog, cat, a bird, rabbit, hamster, gerbil, maybe some other type of rodent, fish or turtle or other small domesticated animal that we traditionally keep for pleasure rather than commercial purposes. So any type of this animal we're looking at. Now, reptiles other than turtles, like snakes, if y'all know me, snakes are not my thing. Not much of this world I don't like, but snakes happen to be on that list. So reptiles other than a turtle, or even barnyard animals, monkeys, kangaroos, or other non-domesticated animals are not considered household animals, okay? So we need to know, is it a household animal? If it is, the the reasonable accommodation should be provided under the Fair Housing Act. So if I come in with my little therapy cat and I just need to pet it because I have some anxiety issues, you should probably provide that accommodation under the Fair Housing Act. If it is not a common household animal, the reasonable accommodation does not need to be provided. Okay. However, there are some very rare circumstances where we might need to allow it. So if the individual requests a unique type of animal that is not commonly kept in the household, then the person asking for the accommodation has the burden of demonstrating a disability-related therapeutic need for that specific animal or that specific type of animal, okay? There could be things such as the person is allergic to pet dander. So having a dog or a cat or a gerbil doesn't work for me because I'm allergic to their dander. Or it could be that another animal can perform tasks that a common household animal cannot. So even though a capuchin monkey, which we see pictured here, is not a common household animal, if I were a person that was quadriplegic and did not have use of arms or legs, I might need a capuchin monkey that is trained to go to the refrigerator, grab a bottled water, bring it back to my wheelchair, unscrew the top, put the straw in so that I can have a drink. A dog or a cat probably aren't going to be able to do all of that for me. I might be able to train them to get the bottle, but pulling off the cap, putting the straw in the bottle, that could be a lot harder. So I might need to allow an animal that's not a common household pet, but the person with the disability requesting the animal has to prove that they need that animal. Okay? So first thing we have to do is we have to determine if that person is a person with disabilities. We need to know what they're asking for and if there's a connection between the disability request for their accommodation animal and their disability. Okay? If it's obvious or known, we don't verify it. Or if we it's not obvious or known, we can verify that information. It's just like a regular reasonable accommodation, but this just applies to animals. There are some general considerations that we need to take into account when dealing with assistance animals. First, we need to remember that the FHA does not require that a dwelling be made available to an individual whose tenancy would constitute a direct threat to the health or safety of other individuals, or whose tenancy would result in substantial physical damage to the property of others. So if you've got somebody who is a threat to the property or other residents, we don't have to allow them in, okay? Now with assistance animals, we cannot charge a fee for processing a reasonable accommodation request. So if somebody comes to us and says, hey, I need an assistance animal, you can't charge them a fee to process that reasonable accommodation request. That's 25 bucks, you need an animal, 25 bucks, I'll decide. We can't do that. Please know that your pet rules do not apply to service or assistance animals. So if you have pet rules and you've got a tenant who has an assistance animal, those rules do not apply to that animal. I would recommend that you have a separate set of service animal rules that apply to the health and safety issues for the property. And when you do that, please know that you may not limit the breed or the size of a dog. So if you have a pet policy on your property that says the dog cannot be more than 15, 20 pounds at full adulthood, you can't say that my seeing eye dog that's a German Shepherd cannot come onto your property. The limit does not apply to a service animal or an assistance animal. However, we may refuse a reasonable accommodation for an assistance animal if that specific animal poses a direct threat that cannot be eliminated or reduced to an acceptable level through actions the individual takes to maintain or control the animal. So if my pet Chihuahua likes to bite everybody that comes around it, I don't have to allow that little Chihuahua to stay at the property. I could tell that tenant that assistance animal needs to go. Or you need to take measures to keep it under control and to keep it from biting other residents. Usually we don't think of Chihuahuas as being dangerous, but those little things are yappy and they like to bite. I'm much more comfortable around a bigger dog like a German Shepherd, but I know those can scare people. And what you really need to do is take it on a dog by dog, case by case basis. Meet the dog. Is this dog displaying any aggressive behavior? Is it well behaved, well trained? So you can't limit the size or breed, but you can look at each individual animal that comes in and determine if it poses a threat. Okay. We also cannot charge a deposit, fee, or surcharge for assistance animal. Any damages that a service animal causes comes out of your regular unit deposit. Okay, so some properties do charge a pet deposit. Those do not apply to assistance animals. The person with disabilities is responsible for feeding, maintaining, and controlling and providing veterinary care for the animal. That is not upon management. We do not have to take care of that service animal or that assistance animal. Okay. So when we're dealing with assistance animals, read that Housing Notice 2020-01. It really provides you a lot of guidance on determining whether people need an assistance animal, service animal, and the documentation that you need for that. Okay, are there any questions about service animals?
Oh, you know they have some. So again, if we don't get it answered, we will reach out to you afterwards. I'm going to go back up, Tim, to the beginning because there was a couple good ones. A lot of them have to do with, like, we have a tenant that has a dog and 4 cats and 8 fish tanks, and how many animals, how many emotional support animals or service animals are you allowed to have?
The big question is, can you limit the number of assistance animals?
Yes.
Generally, no, until it becomes unreasonable. So if you have 3 people in a household, I might have anxiety issues and therefore I need my therapy cat to keep me calm, but I also might suffer seizures, and so I need my therapy dog to notify me when I have a seizure. And then I might have a spouse who is diabetic and has a service animal to notify them that they're about to have low blood sugar. So we have 3 different service animals, assistance animals in our unit. So no, you really can't limit the number. But if it starts to become an unreasonable number of assistance animals, you want to work with your attorney before you tell them, no, you can't have another one.
Okay, good, thank you. If and I'm a cat person, so I'm gonna ask Catherine's question. If the tenant does what they need to do and provides a doctor note saying they need an emotional support animal and it's a cat, can they require that the cat be declawed?
You know, that one is becoming tougher and tougher, because generally our rules with assistance animals need to be for the health and safety reasons. A lot of veterinarians now are refusing to even declaw cats because it's really ripping their fingernails out is what you're doing. So it's getting harder and harder for people to find a vet that will actually do it. Honestly, if that cat is causing damages, you take it out of the deposit and you can bill them for the damages. Hopefully the cat is just really tearing up their furniture and not your carpeting or your doors. But run that past your attorney before you make that a requirement.
Okay. And then we have a couple of like building insurance questions. So I'm going to ask this one. So their insurance, the building insurance does not allow certain breeds of dogs. And what if the service animal is one of those breeds that's not allowed?
Definitely check with your attorney, but my initial reaction is this is a law. You cannot put a fee on a service animal or a surcharge on a service animal, and that would include insurance. Check with your attorney on that one, though.
Okay. I know we have a couple minutes left. Can we deduct expenses for the assistance animal as medical deductions like food, blankets, toys?
You go to the 4350.3 if you're a HUD property, like a multifamily property. Depending on your program, check the handbook.
Okay. And this was funny. I have to ask this one too before we go. There's a lot of questions about taking care of the pet. So what do we do if they are claiming, if a resident is claiming they will not pick up after their pet because they are too disabled?
Well, they need to figure out a way to get somebody to assist them in cleaning up after that. They're still responsible for the care and upkeep of the animal. You may need to make an accommodation to make it easier for them, but no, they are still responsible for the pickup and care of the animal. They might need to have somebody help them walk the dog.
Yeah. And we do have several other questions. So sorry, we're not going to be able to get to all of them because we are already at our 2-hour mark. And see, we thought maybe we would be short on time, but nope. So we do have, we are able to keep your questions. So if we didn't answer them, obviously, during the session today, we will get to you and answer them. Remember, the goal is to, oh good, thanks. There's the expert. You can email him directly too if you didn't have a question that was posted. But remember, we are recording this session. So hopefully, assuming that the recording works and that is viable, we will have that put into a YouTube link, and then we'll upload that to our website for you to access. And I know several of you have asked if we have the ability to share the PowerPoint. So I'm going to get with I'm not sure that the answer to that question. So I'm going to get with our tech gurus and see if that's something that we can also send out to the list of registrants. So that might be an availability as well. But look for your certificates for this training the next day or two via email that you registered under. And then in about a week, make sure you check our website for Tim's presentation. And that's it. So thank you for joining us. I appreciate everybody. We will get back to your questions, but have a great rest of your Thursday. Bye.
Okay, thanks, everybody.